Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video we are going to discuss the preliminary exam paper of Andhra Pradesh Judicial Services 2021. So friends, if you are preparing for judicial services, this channel will be very useful for you. एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. एंड डोंट फॉरगेट टू सब्सक्राइब दी चैनल, एंड व्हाइल सब्सक्राइबिंग डोंट फॉरगेट टू प्रेस दी बेल आइकॉन सो दैट यू कैन गेट द नोटिफिकेशन ऑफ आवर अपकमिंग वीडियोस. सो लेट्स मूव ऑन टू द क्वेश्चंस. क्वेश्चन नंबर 1 इज व्हाट इज द पीरियड ऑफ द इफेक्ट ऑफ अटैचमेंट इन परसुएंस ऑफ द प्रिसेप्ट अंडर सीपीसी. तो मैक्सिमम कितना रहता है? 2 months का. 4 इज द आंसर. प्रिसेप्ट का सेक्शन कौन सा है? Which section is that? Which section relates to precept? Section 46 of CPC. Next is 2. Power of the court to order execution of the decree is subject to dash apart from the condition limitations prescribed by the court under CPC. Subject to discretion, obviously. 2 is the answer, and this is section 51 of CPC. Next is 3. What is the dictum laid in Ahmed Adam Seth versus M.E. Makir by the Supreme Court while filing a suit under section 92 of CPC? अब ये केस पूछ लिया यहाँ पर. They are asking a case. So the decision was a decree in a suit under section 92 will operate as res judicata on all persons who have interest as plaintiffs. So 4 is the answer. Next is 4. With reference to the CPC, read the following statement and select the correct options. Statement A is any person considering himself aggrieved by a decree or order from which an appeal is allowed by the CPC but from which no appeal have been preferred may apply for review of judgment of the court which passed the decree or made the order. This is correct. Which section is for review? देखिए, there are 3 sections: 113, 114, 115. This is reference, review, and revision. Okay. The second statement is any person considering himself aggrieved by a decision on a reference from a court of small cause may apply for review of judgment to the court which passed the decree or made the order. This is also correct. So both are correct. 2 is the answer. Next is 5. In which decision Apex Court invoked the doctrine of actus curiae neminem gravit? That case was BCCI versus Netaji Cricket Club. 4 is the answer. Next is 6. According to Order 7 Rule 2, in a money suit claiming dash, the plaintiff shall state approximately the amount of the value sued for. Immovable property, mean profits, or specific performance or title. Mean profits. 2 is the answer. Next is 7. Which section of CPC prohibits the arrest or detention of women in execution of decree for money? सब जानते हैं. Everybody knows, and this is a repeat question. Section 56. 3 is the answer. Next is 8. Who has to give consent to sue a foreign state within the Municipal Code of India as per section 86 CPC? President or central government? Central government gives the permission. 2 is the answer. Next is 9. Who among the following can file an application for plea bargaining under section 265B of CRPC? Magistrate file करेगा या complainant or accused person? Obviously, who will bargain about the punishment? Plea means an application, and bargaining is, negotiate about the punishment. So who will do that? Accused. 3 is the answer. Plea bargaining is mentioned in chapter 21A. And section 265A to 265L. And now this is chapter 23 and section is 289 to 300 in Bharatiya Nagrik Suraksha Sanhita. Next is 10. Who among the following can record a confession under section 164 of CRPC? registered medical practitioner, no. Police officer, no. Investigation officer, no. Metropolitan magistrate or a judicial magistrate. And sometimes it is mentioned in the option that having jurisdiction or not having jurisdiction. So both can do. Jurisdiction doesn't matter. So 4 is the answer. Now this section has been changed to section 183 in BNSS. Next is question number 11. Which section of CRPC authorizes the court to alter charge? So alteration of charge is provided in which section? 14 or 16? It is in 16. So 4 is the answer. And in new Bharatiya Nagarik Suraksha Sanhita, this section has become section 239. Okay. Next is 12. Under the section 468 CRPC, the period of limitation prescribed for taking cognizance of the offence punishable with fine is, देखिए सेक्शन 468 क्या कहता है कि अगर फाइन ओनली पनिशमेंट है तो 6 मंथ्स है, अप टू 6 मंथ्स. 1 ईयर पनिशमेंट वाला ऑफेंस है तो 1 ईयर है. 1 ईयर अप टू 3 ईयर है तो 3 ईयर है. 3 ईयर एंड अबव नो लिमिटेशन. ओके, एंड दिस इज अ रिपीट क्वेश्चन. तो इसमें 6 मंथ आंसर रहेगा. 3 इज द आंसर. एंड अभी सेक्शन 468 हो गया है सेक्शन 514 in Bharatiya Nagarik Suraksha Sanhita. Next is 13. According to CRPC, the High Court has power to confirm sentence of death passed by the Court of Session under section. Power of confirmation is provided in section 368. 2 is the answer. Submit कहाँ करेंगे? Submission before High Court for confirmation of sentence of death, that is in section 366 CRPC. Okay, now the section 368 has become 409 and obviously section 366 has become 407 in Bharatiya Nagarik Suraksha Sanhita. Next is 14. Which of the following section of CRPC deals with the examination of the complainant? Everybody knows section 200. Easy question have been asked in this paper. Now the section 200 has become section 223 in Bharatiya Nagarik Suraksha Sanhita. Next is 15. What is the maximum period under section 109 of CRPC for furnishing security prescribed for keeping good behavior? As you know, in the previous videos I have also done this question and I have informed you about a chart. You can make a chart like this. Section 106, 107, 108, 109 and 110, 110. So now who will ask for furnishing security? Judicial magistrate, CJM, Court of Session. Okay, and here executive magistrate, EM. This is for 3 year, this is for 3 year, all are for 1 year. And 110 is for habitual offender, 109 for suspected person, ठीक है ना, for keeping peace, in other cases conviction and all that. So 109 is 1 year. 1 year is the answer. 1 is the answer. Now this sections has been changed obviously. Now it starts with section 125, 126, 127, 128, 129 in Bharatiya Nagarik Suraksha Sanhita. Next is 16. According to section 167(2)(a) of CRPC, an executive magistrate may authorize the detention of an accused person in custody for a term not exceeding 3 days, 1 day, 30 days or 7 days. It is 7 days. 4 is the answer. 167 talks when the investigation cannot be completed within the 24 hours. Then if punishable with death or life imprisonment, then the authorization, he can be kept in jail for 90 days. Okay, and in other cases 60 days. After that he will have a right of default bail. Okay, and also
the judicial magistrate can send the accused in remand to police. Maximum 15 days. First 15 days then. Okay, after that there is no PC, only JC, judicial custody. Now the section 167 has become 187 in Bharatiya Nyaya Sanhita. 4 is the answer. Next is 17. Under section 160 CRPC, a woman of 70 years of age can be required to join the investigation at police station or any place decided by the investigating officer. No. At her residence, at the residence of officer in charge of police station. No. 3 is the answer. At her residence, a child or aged person above 60 years, है ना, they cannot be asked to come to the police station. Now the section 160 has become section 179 in BNSS. Alright. Next is 18. General exceptions under IPC are provided under which of the following group of sections? Everybody knows it is from 76 to 106. 4 is the answer. 107 to 120 is offences of abatement. Okay. 121 to 130 is offences against government. So 4 is my answer. 4 is the answer. But now it is changed due to Bharatiya Nyaya Sanhita. Now the chapter of general exception is chapter 3 and section are 14 to 44. Concepts are same. Only sections has been changed. Only section number has been changed. This is 19. A child under 7 years of age accidentally fired a pistol causing grievous injury to a guest. Then a child is punished under the provision of IPC? No. Child cannot be punished. Why? Due to Dolly Incapax. As per section 82, child under 7 years of age cannot be punished for any offense. Isn't that? So 2 is the answer. Now section has become section 20 in Bharatiya Nyaya Sanhita. Next is 20. Section 29A deals with 29 is document. Electronic record is 29A. So 3 is the answer. Variable security is 30, will 31. Now definition has been changed obviously. Document is now defined in section 2 subsection 8 of Bharatiya Nyaya Sanhita. Electronic record is also included in 2.8. Variable security is 231 and will is 34. Okay. Next is 21. A being Z's servant and entrusted by Z with care of Z's car, dishonestly runs away with the car without Z's consent. A has committed which one of the following offences? Theft, dacoity or criminal misappropriation, extortion. He has done theft. How? You can see illustration D in section 378, theft. Okay. Now section has been changed obviously. Earlier this was 378, now it is 303. Dacoity was 391, now this is 310. Criminal misappropriation earlier was 403, now this is 316. Extortion was 382, now this is 308 in Bharatiya Nyaya Sanhita. Next is 22. The right to private defense is not available if there is time to take protection of public authority. This is correct. Against an unsound person नहीं मिल जाता है यहाँ तो it is available. This is wrong. Against child below 7 years of age it is available. There is no time available to take protection of authorities. It is available. So these 3 are wrong because they are asking not available. Not available is 1 is the answer mentioned in section 99 of IPC. Now the section is 37 in BNS. Next 23. What is the minimum number of persons required to constitute the offense of dacoity? Dacoity, how many persons are required? 5 persons. 4 is the answer. Very common question, repeated question. Section is 391 in IPC and now in BNS, as I mentioned earlier, 310.
Next is 24. The minimum number of persons required for committing an AFRE under Section 159 IPC is 2, 4, 6, 7. 2 persons only. One is the answer. AFRE is an offense against public peace. Now AFRE has come under Section 194 in Bharatiya Nyaya Sanhita. Next 25. What is the minimum period of imprisonment prescribed for the offense of theft? In Section 379 definition theft की है 378. The punishment in 379 has been mentioned as 3 years. So 3 is the answer. Now Section 378 has become 303. Punishment is also provided in 303. Next 26. Confidential communications between legal advisor and client are privileged under the protected under which section? Section 129 Indian Evidence Act. 2 is the answer. Section 133 is accomplice. Now accomplice is in Section 138. 129 has become 134, 135, 140. This is order of examination of witnesses. 134, number of witness. How many witnesses are required? 0, no particular number. 134 has become 139 in Bharatiya Sakshya Adhiniyam. Next 27. Which of the following statement is correct? Witnesses shall be first examined in chief, then re, then cross. This is not correct. After examination in chief, it is cross, then re. And examine in chief, cross and re. This is correct. Examine cross first. No. So 2 is the answer. As I mentioned, the order of examination in Section 138 Evidence Act. Now this has become Section 143 in Bharatiya Sakshya Adhiniyam. Next 28. According to Section 3, effect is said not to be proved when it is neither proved nor disproved. This is correct. Discretion of the court. No. 1 is the answer. Mentioned Section 3 interpretations. Now obviously this has been changed and this is mentioned now definitions in Section 2 of Section 2I of Bharatiya Sakshya Adhiniyam in the definition of not proved. Next 29. Which of the following statement is correct? Witness to character cannot be cross-examined, cannot be re-examined. Leading questions cannot be asked in cross-examination. These all are wrong. Person summoned to produce a document cannot be cross-examined unless and until he is called as witness. This is correct. This is mentioned in Section 139 Indian Evidence Act. So 4 is the answer. And witness to character can be examined and re-examined. So this is mentioned in Section 140 Evidence Act. And leading question can be asked in cross-examination is 143. Now obviously they have changed. 140 is now 145, 143 is 146, 139 is 144 in Bharatiya Sakshya Adhiniyam. Next is 30. When is a voluntary confession admissible in evidence made to a police officer? No. When are made to magistrate having competent jurisdiction? This is correct. To village sarpanch? No. When it leads to no discovery? No. Leads to discovery of facts. Mentioned in Section 27. This is in 26. 2 is the answer. Now this all has been come under Section 23 in Bharatiya Sakshya Adhiniyam. Next question number 31. Section 74 of Indian Evidence Act deals with public document. Now 1 is the answer. Burden of proof starts from 101. Leading question is in Section 141. Accomplice 133. Now as I have mentioned earlier, all the sections has been changed. Public document and private document both has come under Section 74. Burden of proof is now in Section 104. Leading question is 146. Accomplice 138. Alright. Next 32. Which of the following section of Indian Evidence Act deals with estoppel? Estoppel कहाँ पर है? In section 115. 4 is the answer. Now the section 115 has become 121 in Bharatiya Sakshya Adhiniyam. Next is 33. Under which of the following section of Indian Evidence Act the court shall presume that a person had caused the dowry death? Dowry death section everybody knows it is in 113B. 1 is the answer. Now the section has become section 118 in Bharatiya Sakshya Adhiniyam. Okay. Now 34. A fact under the Indian Evidence Act is said to be dash when, after considering the matter before it, the court either believe it to exist or consider its existence so probable that prudent men ought, under the circumstances of the particular case, to act upon supposition that it exists. That is proved. So 1 is the answer. Not prove I have already discussed in the previous questions. Earlier this interpretation was in section 3 of Indian Evidence Act. Now this section has been changed. Definition has come under section 2 of Bharatiya Sakshya Adhiniyam and proved is under 2 clause J. Next 35. Which of the following case the doctrine of res justice was applied by the Supreme Court? It was applied in Ratan Singh versus State of HP. 3 is the answer. Next is 36. With reference to Indian Evidence Act, read the following statements and select the correct option. Statement A is statement made by a party to suit, suing or sued in representative character are admission unless they were made while the party making them held that character. See, this should be are not admission unless they were made. Okay, so this statement is wrong. Mentioned in section 18 of Indian Evidence Act. Further, the statement B is statement made by a person to whom a party to suit has expressly referred the information in reference to a matter in dispute are admissions. This is correct. Same section. So A is incorrect, B is correct, 3 is the answer. Next is 37. In which case the Supreme Court held that the statement recorded under section 161 CRPC would be treated as a DD under section 32 of the Indian Evidence Act if the injured declarant died. That case was Mukesh Bhai Gopal Bhai Barot versus State of Gujarat. 4 is the answer. Now DD has come under section 26 in Bharatiya Sakshya Adhiniyam. Next 38. Which section of Indian Evidence Act deals with presumption as to electronic signature certificate? कई बार पूछ चुके हैं, इसे repeat question, isn't that? ये 85C 3 is the answer. Now this has become section 87 in Bharatiya Sakshya Adhiniyam. Next 39. Which of the following statement is not true as per the Indian Contract Act? A contract to do or not to do anything in if some event collateral to such contract does or does not happen is a contingent contract. This is totally correct, mentioned in section 31. Then contingent contract to do or not to do anything if uncertain event happens cannot be enforced by law unless until that event happened. This is also correct, mentioned in section 32 of Contract Act. Next is contingent contract to do or not to do anything in an uncertain event does not happen can be enforced when the happening of that event become impossible and not before. This is totally correct, mentioned in section 33. Then contingent contract to do or not to do anything if a specified uncertain event happens within a fixed time becomes void if at the expiration of the fixed time such event has not happened. So this is wrong, mentioned in section 34. So which is not true? 4. 4 is the answer. Next is 40. A was offered a flat by B by way of lease on deposit of sum of money within 3 years. It did not deposit the money for 3 years. What is the remedy available to B as per section 6 of Indian Contract Act? It is a revocation, no remedy, persuade A to make payment, no. B can revoke it for failure of the acceptor to fulfill the condition precedent to acceptance. 2 is the answer. Section 6 यही तो कहता है revocation. Revocation how made? Section 6 is about revocation of offer. Next is 41. A agreed to sell to B his white horse for rupees 500 or rupees 1000. What kind of agreement is this between A and B? This is a void agreement, void for no consideration of contingent of uncertainty. 3 is the answer. Section is for uncertainty, section is 29. For no consideration, 25. Okay. Contingent contract, just mention section 31 of Contract Act. Next is 42. Which section of Indian Contract Act states that consideration is not necessary to create an agency? The repeat question we have already discussed several times in ANDHRA's questions itself. It is section 185. 3 is the answer. Next 43. According to section 14 of Specific Relief Act as amended in 2018, which of the following cannot be specifically enforced? A contract which is not dependent on the personal qualification, then it can be enforced. A contract the performance of which does not involve the performance of a continuous duty which the court cannot supervise, it can be enforced. Where a party to the contract has not obtained substituted performance, it can be enforced. Then a contract which is in its nature determinable, so here you cannot enforce it. So this cannot be enforced. 4 is the answer. Next 44. Under section 2 of Specific Relief Act, dash includes every duty enforceable by law. Obligation, section 2 clause A, first definition in Specific Relief Act is of obligation. 2 is the answer. Next 45. As per section 11 of Specific Relief Act, a contract made by a trustee in excess of his power or dash cannot be specifically enforced. Excess of his authority, a violation of his duty or his function, or breach of trust. Section 11 is for breach of trust. So 4 is the answer. Excess of his power has been already mentioned here, na? So the next option left is breach of trust. Next 46. Section 20A came by 2018 amendment, deals with expeditious disposal of suits या फिर special code contract relating to infrastructure project. 3 is the answer. Next 47. According to Specific Relief Act, where an instrument is evidence of different obligations, the court shall enforce, shall cancel, may cancel in part, allowed for stand for residue, may declare entire instrument void, may cancel it in part or allow it for the residue. 3 is the answer. And this is mentioned in section 32 of Specific Relief Act. Next 48. Which section of Specific Relief Act deals with injunction to perform negative agreement? This is in section 42. 4 is the answer. 40 is damages in lieu of or in addition to injunction. 41 is injunction when refused. Alright, 43 is no section. Next 49. No injunction shall be granted by a court in a suit under Specific Relief Act involving a contract relating to infrastructure project specified in the schedule, where granting injunction would cause impediment or delay in progress of the completion of the project. This is correct. Public discomfort, no. For development activity, no. Repairable financial loss, no. 1 is the answer. And we have just discussed this section as well. Section 20A came by 2018 Amendment Act. Okay. Next is 50. As per Hindu Succession Act, where two persons have died in circumstances rendering it uncertain whether either of them, or if so which, survived the other, and then for all purposes affecting succession to the property, it shall be presumed until contrary is proved that elder survive the younger या फिर younger survive the elder. Elder survive मतलब elder बच गया, younger मर गया. इसमें है यंगर बच गया, एल्डर मर गया। तो पहले ऐसे सोचेंगे दोनों इकट्ठी मौत हुई है, तो ये यही सोचेंगे कि भाई कि इसमें जो है यंगर बाद में मरा है, पहले एल्डर मर गया था। ओके, सो 2 इज द आंसर। एंड एक कहाँ मेंशन है, सेक्शन 21 ऑफ हिंदू सक्सेशन एक्ट। नेक्स्ट 51, as per Hindu Succession Act, if 2 or more heirs succeed together to the property of an intestate, they shall take the property per capita and not dash and as tenant and tenants in common and not as joint tenants. So not per stripes. Okay, so per stripe tenant in rem, no joint tenant. So 4 is the answer. Next 52, according to section 22 of Hindu Marriage Act, every proceeding under the act shall be conducted in camera and it shall not be lawful for any person to print or publish. In camera का मतलब क्या होता है, private. This is a legal maxim, or you can say a Latin term. Print to publish any matter in relation to any such proceeding except a judgment of the High Court or Supreme Court, printed or published with the previous permission of the court. Okay, so 3 is the answer. Next 53, section 29(2) of Hindu Marriage Act retains the customary ground and mode of divorce that existed before coming into force of the Hindu Marriage Act. This is correct. Prevent dissolution customary, no. Provides alimony, no. Bar divorce for 1 year, no. 1 is the answer. It do not prevent, not prevent. Mention in section 29(2) itself है ना. And provides alimony. Alimony section कौन सा है? It is section 25 of Hindu Marriage Act. And bar of divorce within 1 year of marriage is in section 14. Okay. Next 54. A claim to any debt other than debt secured by mortgage of immovable property or by hypothecation of pledge immovable property is known as dash under TPA. Mortgage or hypothecation has not been defined in TPA. Marshalling security is there in section 81, mortgage 58. It is an actionable claim. 4 is the answer. And definition of actionable claim has been mentioned in section 3, interpretations of TPA. Next 55. A transfer is found to be for his life with the proviso that in case B cuts down the certain wood, the transfer shall cease to have effect. B cut down the wood. What is the effect of the transfer as per section 31 of TPA? B's interest in the farm does not cease. If B loses his life interest in the farm, the condition has been violated, so it will be void as per section 31. So 2 is the answer. Next 56. In which case the Supreme Court held that release deed is a conveyance and hence transfer of property within the meaning of section 5. This case was Kumar Harish Chandra versus Bansidhar Mahanti. 1 is the answer. Next 57. Which of the following statement is not true with respect to TPA? The right conferred by section 60 is called a right to redeem and a suit to enforce it called a suit for redemption. This is correct. The provision of section 68 do not apply in case of mortgagee who is and has been in possession. This is also correct. In case of usufructuary mortgage, the mortgager has no right to recover. How it is possible? It is a mortgage and every mortgager has a right to recover the possession of the property. So this is wrong. Any person who has been named in the mortgage deed is willing and able to act as receiver may be appointed by the mortgagee under section 69A. This is correct. So what is not correct? 3. 3 is the answer. Next is 58. Which section of TPA deals with marshalling securities? I just informed you, है ना? That is section 81. 4 is the answer. Section 78 is postponement of prior mortgage. 79 is mortgage to secure maximum amount. It is deleted. Alright. Next 59. A. The lessor gives B, the lessee, notice to quit the property leased. The notice expires, B tenders and A accepts rent which has become due in respect of the property since the expiration of the notice. The effect is waiver हो गया notice का ना, notice waived हो गया. Future rent stand waived, no. Notice is waived. Notice remain valid, no. Become unenforceable, no. 2 इज द आंसर। भाई नोटिस दिया खाली कर दो, फिर बी उसको पैसे देता है कि भाई नहीं मैं रह रहा हूँ, मैं रेंट दे रहा हूँ, बी ए उसको एक्सेप्ट कर रहा है, दैट इज वेवर ऑफ नोटिस। You can see section 113 and illustration A for this. Next is 60. As per section 20 of Registration Act, the registering officer may in his discretion refuse to accept for registration any document in which any interlineation, blank, erasure and alterations are there. So 3 is the answer. Repeat question. Next 61. According to section 32A, every person presenting any document at the proper registration office under section 32 registering shall affix his passport size photograph and fingerprint to the document. जो फोटो खींचने का जो ये सिलसिला शुरू हुआ था, ये 32A की अमेंडमेंट जो आई थी उसके बाद से स्टार्ट हुआ था. It was started after this amended section 32A has been inserted in the Registration Act. 1 is the answer. Next 62. Which of the following section of NI Act was amended by the Negotiable Instrument Act 2015? This is a tough question. You also need to now look at the sections and their amendments and which section has been amended at what time. So it was section 6. 2 is the answer. The word check in electronic form has been inserted in section 6. Okay. Next 63. Section 117 of NI Act deals with 17 क्या है? Rule as to compensation. 1 is the answer. Check crossed specially is section 124. Crossing after issue 125. Presumption on proof of to protest section 119 in NI Act. Next 64. Section 143(3) of Negotiable Instrument Act provides that an endeavor should be made to conclude a trial within 6 months from the date of filing of the complaint, and 3 months and 9 months or 1 year. It mentions a time period of 6 months. So 1 is the answer. Next 65. Section 147 of NI Act provides that every offence punishable under Negotiable Instrument Act is compoundable. 3 is the answer. Bailable तो होता ही है. Next 66. Section 5 of NI Act defines bill of exchange. 2 is the answer. Section 6 I just mentioned, check है ना, promissory note is section 4. Inland instrument is in section 11. Okay. Next 67. According to section 2(3) of Juvenile Justice Act, adoption regulation means regulation framed by the authority and notified by the central government. Obviously 1 is the answer. Next 68. According to section 2(4) of JJ Act, administrator means any district official not below the rank of dash. It was deputy secretary actually, but after the amendment of 2021, this section has been deleted. So this question is not relevant for us now. Next 69. According to section 235 of JJ Act, juvenile means a child below the age of 18 years. 2 is the answer. Repeat question, very common question. Next 70. According to section 27 of JJ Act, a person cannot be appointed as a member of Child Welfare Committee for a period of more than 3 years. 2 is the answer. Next 71. According to section 28 of JJ Act, the Child Welfare Committee must meet at least 20 days in a month. 3 is the answer. Next is 72. Definition of suit for the purpose of Limitation Act does not include. तो सूट में क्या नहीं आता? प्लेन रिटन स्टेटमेंट आते हैं, इंटरलोक्यूटरी एप्लीकेशन, एफिडेविट आते हैं, एक्स पार्टी पिटीशन, रिव्यू पिटीशन आते हैं. अपील एंड एप्लीकेशन नहीं होते ना, वो डिफरेंट है. सो 1 इसका आंसर रहेगा. वो सूट की डेफिनेशन कहाँ प्रोवाइड की गई है? इन सेक्शन 2L ऑफ लिमिटेशन एक्ट डेफिनेशंस में. नेक्स्ट 73. अकॉर्डिंग टू सेक्शन 8 ऑफ लिमिटेशन एक्ट, नथिंग इन सेक्शन 6 or 7 applies to suit to enforce right of unborn child in the womb, pauper, preemption and sound person. It is of preemption. 3 is the answer. सेक्शन बता ही दिया. Next 74. Read below statements. Select the correct option. Statement A is for the purpose of section 19. That includes money payable under decree or order of the court. No, this is wrong. All instruments for the purpose of limitation act shall be deemed to be made with reference to Saka calendar, no, Gregorian calendar. This is mentioned in section 24 of limitation act. So both statements are incorrect. 4 is the answer. Next 75. As per the provisions of limitation act, where once time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. 2 is the answer. Section is section 9. Next 76. What is the statutory time period prescribed under section 25(3) of limitation act to establish absolute and indefeasible easement? Now see the section they are asking 25 subsection 3. So this is for the government. Against the government, the easement period should be 30 years. 4 is the answer. Against a private person, 20 years. Next 77. The expression beneficial enjoyment in section 4 of the Indian Easement Act does not include क्या नहीं होता? Possible convenience, yes. Remote advantage, mere immunity. Servient heritage is not there. So 4 is the answer. Next is 78. Choose the correct option. Statement A is a right annexed to A's house to prevent B from building on his own land. This is an apparent easement though. This is not an apparent easement. This is wrong. A right of way annexed to A's house over B's land. This is continuous easement. This is a discontinuous easement. So this is also wrong. This is mentioned in section 5 of Easement Act, and this is illustration D, and statement B is illustration B. Alright, so both are incorrect. 2 is the answer. Next 79. Which of the following statement is incorrect with reference to Easement Act 1882? A lessee of immovable property can acquire for the beneficial enjoyment of other immovable property of his own an easement in or over the property comprised in his lease. No lessee of immovable property can acquire. Alright, so this is wrong. Mentioned in section 12 of Easement Act. This is incorrect. One or more two co-owner of immovable property may, with consent of the other or others, acquire an easement for the beneficial enjoyment of such property. This is correct. Two or more co-owner of immovable property may, as such, without the consent of the other, acquire an easement for the beneficial enjoyment of such property. This is correct. An easement may be acquired by the owner of the immovable property for the beneficial enjoyment of which right is created. This is also correct. So 2, 3 and 4 are correct. 1 is incorrect. 1 is the answer. Next is 80. Under section 17 of Indian Stamp Act, all instruments chargeable dash with duty, obviously, executed by any person in India shall be stamped before at time of execution. So 2 is the answer. Next 81. Which of the following is correct or incorrect? Statement A is instrument unduly stamped is inadmissible in evidence. This is correct. Mentioned section 35 of Indian Stamp Act. This is B. Every instrument written in contravention section 13 or 14 of Indian Stamp Act shall be deemed to be unstamped. This is also correct. Mentioned section 15. Next is C. The collector can stay prosecution in respect of any offence punishable under the Stamp Act and compound any such offence. This is also correct. Mentioned in section 70. This is incorrect. How? The collector do not have power to compound the offence. Mentioned in section 70 of Indian Stamp Act. So A and B are correct. C is incorrect. 3 is the answer. The Chief Controller of Revenue has the power for composition of the offences. Okay. Next 82. What is the maximum period of imprisonment prescribed for a breach of protection order by respondent as per section 31 of the Protection of Women from Domestic Violence Act? This is for 1 year. 3 is the answer, and there is also a fine of up to 20,000 rupees. Next 83. Section 2N of DV Act defines protection officer. 1 is the answer. Domestic relationship is in section 2F.
dowry to H, protection order to O. Okay. Next 84. Which section of DV Act deals with the appointment of the protection officer? Section 8. 1 is the answer. 14 is counseling. And 18 is protection order. Next 85. Section 19 of DV Act deals with residence order. 4 is the answer. Protection order in 18. Custody 21. Compensation 22. Next 86. Section 212 of Andhra Excise Act defines excise revenue. 2 is the answer. Excise tree is in 213. Export 14. Foreign liquor 15. Okay. Next 87. As per section 228 of Andhra Excise Act, what is the meaning of sale or selling? Sale or selling includes any transfer otherwise than by way of grant, loan, gift or barter. Otherwise way of gift. 3 is the answer. Next 88. What is the time period prescribed under section 46C of Andhra Excise Act 1968 for filing an appeal? It is a 60-day time period. 2 is the answer. Section is already mentioned here. Next 89. Which of the following section of Andhra Excise Act deals with compounding of offences? It is section 47. 4 is the answer. 46F is property confiscated when vested in government. Means whatever property has been confiscated and at what time it will become the property of government. 50 is penalty for abatement. Okay. 49 is penalty for prohibition and excise officer refusing to do duty. Next is 90. What is the maximum period of imprisonment prescribed under section 9(1) of the Andhra Gaming Act for gaming in public street? 3 month की punishment है. So 3 is the answer, and also fine of ₹300. Next 91. Which of the following section of AP Gaming Act deals with presumptive proof of gaming? This is section 11. So 1 is the answer. 7 is provision of 4 and 6 not to apply in certain cases. Okay. Section 9 is penalty for gaming or setting birds in public street. 12 is instrument of gaming. Next is 92. Which of the following section of Andhra Gaming Act defines gaming? This is defined in section 2(2). 4 is the answer. 1(3) is when this act came into force, and 1(2) is extent of the AP Gaming Act, which is up to only Andhra Pradesh. Next is 93. What is the maximum term of imprisonment prescribed under section 4 of Andhra Gaming Act? It is 6 months. 4 is the answer, and there is a fine of ₹3,000 as well. Next is 94. Who is authorized person to give prior notice for proceedings under section 5 or section 6 for unauthorized occupation of any land as per section 7 of AP Land Encroachment Act 1905? It is collector or tahsildar or deputy tahsildar has the power. So 2 is the answer. Next 95. What is the limitation period to move an appeal against a decision or order as per section 11 of AP Land Encroachment Act? It is 60 days from the date of order or from the date of receipt of the copy of decision or order. 3 is the answer. Next 96. Which of the following is true as AP Civil Rules of Practice? The parties shall sign at the foot of the pleading, and any one of them shall also sign at the end of each of the other pages. This is correct, mentioned in Rule 26.
Verification of pleading shall be made just above, no, below the paragraph claiming, okay, and it is next below the paragraph. So this is wrong. Mention Rule 26 itself. Then next is where two or more suits are in a way connected with each other, the party or his advocate shall not file a memo. They shall file, shall need to file, should be like this. I think this language is wrong here. Describing the cases in which he is connected. There are some spelling mistakes in the paper. Anyway, this is wrong. This is Rule 25. Next is 4. Where upon examination the plaint is found to be in order, it shall be entered in the register of judges' suits. Rule 23. So, which is correct? 1. 1 is the answer. Next, 97. What is the maximum time period fixed for delivery of judgment reserved after hearing the parties as per Rule 142 of Civil Practice? It is 60 days. 2 is the answer. Now, see, they are asking maximum time. In the rule, it is mentioned you should provide the judgment in 30 days. You should deliver the judgment in 30 days. But maximum can be 30 plus 30, maximum 60 days. Next is 98. As per Criminal Rule of Practice Circular Order, Andhra Pradesh criminal courts dash in case where there are more accused than one, may permit or deny the accused to present the other as per the discretion of the court. No, will never permit. May permit the accused to represent the other, but only after the authorization in writing and signature of the person giving it and its filing in the court. 4 is the answer, and this is Rule 37 in AP Criminal Rules of Practice and Circular. Next, 99. The Criminal Rule of Practice laid down that no magistrate shall record any statement or confession made by an accused under Section 164 of CRPC. Statement and confession are where? In Section 164, obviously, which is now has been changed to 183 in BNSS, until he explained to the accused that he is under no obligation to answer so and so and so. So 2 is the answer. Next is 100. As per Criminal Rules of Practice and Circular Order of AP, court shall ordinarily sit from 10:30 to 5 p.m. 4 is the answer, and this is Rule 3. Okay. So friends, here we have discussed all the questions of preliminary exam paper of Andhra Pradesh Judicial Services 2021. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं फ्रॉम, तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.